Seema Modi, a core committee member of World Cybersecurity Forum, welcome you all to the case analysis workshop organized by World Cybersecurity Forum. WCSF is an internationally renowned cyber consultancy and web community that improves cybersecurity awareness and acts as a source of techno-legal information for professionals, students, and teenagers around the world. On 1st April 2020, WCSF launched Cybercrime Awareness 2020 program, which is a global initiative to support emerging trends in cyber law, cybercrime, and cybersecurity. Increasing the level of cyber awareness through education and training can be an effective way to encourage the adoption of security tools, which leads to safer use of technology. The objective of the case analysis workshop is to educate young cyber enthusiasts about the cybercrime and its various stages in solving it. Now, it gives me immense pleasure to welcome Ms. Kajori Bhatnagar ma'am, who is specialized in IPR and Cyber Laws from ILI Delhi and Asian School of Cyber Laws. Ma'am obtained her Masters of Law in Human Rights from National Law School in India University. She then pursued a specialization in advanced entrepreneurship management and corporate laws from Gujarat National Law University. She is currently working as an assistant professor and research scholar at Panjab University. She has experience as an academician for over 3 years. She is a vehement promoter, propagator, and follower of human rights. We're really glad to have you, ma'am, amongst us. I thank you, ma'am, and welcome you, ma'am, on behalf of WCSF for taking out time and for enlightening us with your knowledge. I would request the attendees to post your questions or queries in the comment box provided. Thank you so much. Now, I would request ma'am to begin with the session and take over. Thank you so much, ma'am.
Okay. First of all, I must thank you and I must welcome everybody to this August nice sunny Sunday afternoon. So I'm having it's my immense pleasure to discuss on this particular topic. That is, we are going to talk about this case analysis. But of course, when we talk about this case analysis, I would say it is one of the precedents, but we have a lot of nuances of IT law, a lot of nuances where our IPC, a lot of nuances where our law is lacking. And it is also going to be fitting in certain aspects that we should definitely be looking at. Okay. So first of all, thank you for having me. And definitely I would like to share my opinions with you people and share my ideas and thoughts about this particular case. So let's just begin with one very, very small quote and a very small sentence that I would like to share with you people. That is, the law at this point of time, as far as our technology is concerned, law is way behind our technology. This is one statement that I personally totally believe in because of very simple criteria that somewhere law has not been able to catch up with the advancements in technology. We are still way behind. The technology is moving faster. The law is not catching up. And there's some other place that a vacuum is left for deliberation, for legislation, and for regulation of the same. We started with a very small system of having an internet that diversified into sharing and having an internet on the palm of your hand. And now with that, we have so many things that is happening all over the internet. We are communicating cross continents, we are communicating cross seas. This is definitely a kind of a deliberation that we need to govern. We need to see what it is all about, right? So starting with the first thing, I would like to share a couple of slides, trying to just point out, this is a very, very simple format of a slide that I'm trying to share with you. It's not nothing elaborate about the case. What I have done about the case is that I have picked down certain aspects of the case that we need to discuss, right? Because you see, when we're talking about the case analysis, of course, we are going to talk about how, whether the Google was there, whether we should have had, or whether Google should have actually been held as far as liability is concerned. Going by the court's judgment and what was going on in the trial court, in the High Court and Supreme Court, I would actually like to point out that there are certain defects and certain highlights that have still not been pointed out. Okay, so let's begin with the first part itself. Let me share my slides with you. I do get this option, right?
Yes, ma'am, you have. Yes.
Right. So are my slides visible? Just let me start.
Yes, ma'am, it's visible.
Why is it not happening? Right. Case analysis, that is Google India Pvt Ltd versus Visakha Industries, AIR 2020 Supreme Court 350. Okay, then we come to the next one, and that is law and technology interface. The relations between law and technology are both simple and exceedingly complex. At the most elementary level, technology consists in the application of labor to create a product, to generate a service, or otherwise to produce a desired result. Technology develops as ways are found to produce new results or to produce old results using fewer or less costly inputs. Law is generally understood to exist as a set of rules adopted by a society's governing institutions that are applicable to all of its inhabitants. Law and technology interact when legal rules foster or retard the development of technology. They also interact when society decides that technology produces undesirable results and employs legal rules to contain or modify those results. I would really like to bring your attention to the last line, that is, law and technology interact when legal rules foster or retard the development of technology. So, when we are talking about, and let's just take this case as our example here, we can very well see what it is all about. While we were discussing this particular case of Google Limited versus Vishakha, we very well noticed that what is particularly happening in this case. First of all, there was an instance of defamation. Okay, so we are going by the very fact that there is a defamation, and defamation not precisely within the definitions of traditional defamation as discussed in IPC, but it happened on cyberspace. That was the first aspect of this particular scenario. Okay, now the second aspect, when I talk about this last line, we can see it is a development in trend. So for defamation, nobody is going towards the print media anymore. We are going towards internet, an easier way. The mass dissemination of information with just a click of a button. So that is what our information and the spread and dissemination of information works like. Then our second aspect that came in this particular case was that although the idea of defamation, whether there was a defamation or not a defamation, that was a thing that was not even deliberated much upon. What was much upon was whether are we going to hold Google LLC, that is the subsidiary of the main Google NIC, there to be held responsible for the issues under intermediary, because at that point of time, when this case actually began, the law at that point of time was not functional, right? It was not giving intermediaries the benefit or the blanket protection that it gave after the amendment came into being. So that is the two main highlights of the whole issue that go on in this particular case. That is what has been the role or the evolving role of the intermediaries, and exactly what was the defamation per se. So coming to our next slide and coming to the very idea, right, that what are intermediaries and what exactly defamation is. First, let's come to the idea of what exactly are intermediaries. Okay, now intermediaries per se are a kind of, you could say they are those kind of uh, intermediaries are a middleman. In a simple literal language, we can say intermediary are middlemen between the consumer and the producer. In very simple words, middlemen are what like intermediaries are. But when we use it in terms of information and technology, intermediaries are going to be used as facilitators, right? They are the ones who are facilitating the exchange of information from between the producers and or the providers, service providers, to the consumers. So they are bringing, or they are actually a platform. So this is what is the function of an intermediary when we are talking about this aspect. Now going to the legal definition of how it is defined under IT Act. Now intermediary is defined under section 2W of IT Act 2000, which says that intermediary with respect to any particular electronic records means any person who on behalf of another person receives or transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. You see, this is a very simple definition, which is very self-explanatory by itself, which says that intermediary per se is going to be anything or a mode which is going to help in interaction between the consumer and the service provider. As simple as that, right? So these are the various types of intermediaries that have generally been discussed. Like we have the internet service providers such as the Airtel and MTNL, which helps users to get connected to internet by means of wired or wireless connections. Then we have search engines like Google and Bing. Then we have DNS providers. These service providers translate the domain names to addresses that can be understood by computers. Then we have web hosts like the GoDaddy.com. Then we have interactive websites that we have Facebook and Twitter. And then we also have our blogging platforms like Blogspot and WordPress. And we have auction sites like eBay and PayPal and such situations. Then we have cyber cafes per se, right? Okay. Now, when we come to these aspects, now the whole situation and the whole definition and the complexity between the the intermediary starts right here. First of all, what happens is that once we see the definitions of what all are the types of intermediaries, we would slightly have to go back to the very idea of evolution and understanding of internet in our country. So first of all, our regulation started with the places that was providing internet. So that regulation was our cyber cafes. That was going on too much, and that is how they were regulating the entry, the exits, how the people have to write their names to exercise or to use cyber cafes, till we actually had a wired connection that was coming, the broadband that we were having at our places that was used via phone connections, and the phone used to be connected, and that's how we were able to have our internet. That was the first step of it. Then came the regulation where we were trying to regulate what is how the internet is coming, who are providing those services, how are those services happening. But very off lately, what we are not able to target is how are we supposed to control and regulate as to what is being shown, or we use a simple word, what is being published or what is being broadcasted. That is something that the emphasis has not been upon for a very long time. And nobody has actually, for that matter, no, this idea or this has been the biggest vacuum ever. If you even see now, the latest, even the latest IPC provisions, we will have a lot of amendments. But nowhere, when we talk about defamation, let's just take that particular example. We have used the word publish, and we interpreted that it is published anywhere. But if you just see the bare language, nowhere has it used. Where is we going to use the word publishing? How are we going to use the intermediaries, although we have defined them, although we have seen the intermediaries and their liabilities, but then what is going to constitute publishing? What is going to constitute the intermediaries? How are we going to define their liabilities? That has always been a situation of conflict. Coming before that, the protection to intermediaries can be discussed under 3 stages. Stage 1 is no protection. Stage 2 is safe harbor. And proposed amendments are given here that have been the latest guidelines of 2021 as regards the intermediaries. Now, why have I divided in these 3 parts is that even when you go through the case and how the courts have interpreted the definition of the case, how the courts have interpreted till the Supreme Court, the whole idea of the intermediary protection, that is something we need to take care of, and that is something that we need to see. So the first step itself is no protection. So when intermediary, the first idea of intermediary, that is before 2009 when it started, the first idea was that intermediary will have no protection. In simpler words, it was like that the person had to prove that they had taken due diligence, and whatever publication that happened without their requisite knowledge. So that was the first step of uh, of your no protection in case of intermediaries. However, situation changed after the Bazi.com case, or as we popularly call as Avinish Bajaj case. This was in relation to the MMS clip that was being shared on eBay. After this particular case, there was a change in the law of intermediaries. And in the year 2009, there was a concept of safe harbor, 2009, sorry, the safe harbor, that the intermediaries were then given a protection, which said that the intermediaries here are just the facilitators. They are not supposed to be held liable, they're not supposed to be held liable unless it is shown that they, despite having the knowledge, despite having everything, they did not remove they did not remove the issues that have been considered as obscene, that have been considered as with malified intention on the particular intermediary, right? Now, if you see the proposed amendments, that I will come at a very later stage, probably the last stage of our discussion today, when we talk about what the proposed amendments and what are the intermediary guidelines that they're trying to discuss. Just giving a very, very brief idea about it. The government mostly is trying to regulate social media. Of course, like we have already discussed, the interactive sites also come under the realm of our intermediaries. So the focus here has been to regulate the social media, put them under OTT, and probably give them a line of regulation as to what the intermediary content has to be. And if they're trying to post or there is some content, and have a self-regulation or filtering mechanism right at the very beginning to ensure that no such matter is being shared online that is prejudicial to the normal interests of the people. So those are the particular amendments of the same. Right. So now coming back to this case and what exactly happened. Now, in this particular case, as we all know, this case here was about a defamation, a line of a defamation that was held by the person concerned. The line of defamation here, where the person actually said that the person here, we have three people concerned: the person who was defamed, then the second company who had written about it, the third, the Google LLC, that was actually on which the defamation was published, and fourthly, the Google Inc. itself. So after these four party concerns, what we just now are, and what is the main concern here was, number one, when the person actually filed for defamation, there has been a confusion regarding the fact whether the person was actually asked by the person who was defamed to remove what was given on the particular sites as a blog post. What it is just said in a lot of cases was that probably you will have to take the you will have to take down these URLs. You have to send the URLs that you feel are not appropriate in regard to your discussions. So now what the defense by the Google was that the URLs were never provided to them, so they did not remove it. That was one aspect of it. Secondly, what Google actually said was that Google LLC in India is just a subsidiary of the main Google company. So that is why it cannot be held responsible for the activities that has been particularly taken care of by the main Google server themselves. They are not supposed to be liable for that. The third defense that they actually took was under the defense of the present law, that is 79, section 79, which is dealing with the intermediary laws. However, what we have to just see is that technically what the courts applied was that when the cause of action actually arose, at that point of time, intermediaries did not get a protection. So in that particular case, the Google will never not get a benefit of doubt in this particular matter. So Google was asked to pay a compensatory cost to the person who was defamed. Right. So now precisely, whenever if you read the whole judgment, they have not precisely written the lines that have been considered as to what would actually constitute defamation. Okay. So now coming to the very part, and again, like when we discuss this particular case, I'm yet again using the word again and again as to what is a safe harbor. If you see this particular diagram, it will explain the word safe harbor. That is 2009, a very prominent defense that was taken by Google LLC in India about why should they not be held liable under Section 17(9). This was it. This was at the online portal is an intermediary, that is, it either receives, stores, transmits, or provides service respect to an electronic record of another, right? Then the portal does not initiate, select the receiver of transmission and select or modify the transmission and observes due diligence and while discharging its duties and observes guidelines prescribed by the central government. The portal is not exempt from liability. The portal's function limited to providing access to a communication system over which information made available by third parties is transmitted or temporarily stored or hosted, right? However, in case the portal has conspired, abetted, aided, or induced, whether by threat or promise, the commission of an unlawful act, upon receiving actual knowledge or being notified by the government or its agency that any information, data, or communication link residing in or connected with in such portal is being used to commit unlawful act, the portal fails to remove or disable access to that material without vitiating the evidence in any manner. The portal will not be exempt from liability. So we can see both the situations where the internet portal would be held liable and in the cases where it would not be held liable, right? Now, the only thing here is, yet again, there has been a defense by majority of the portals here, especially when they're taking the defense of intermediary, that is that they did not connive or they did not abet the offense to take place. All they did was that they acted as facilitator for sharing the particular information. And this is what particularly was the defense of Google in this particular case also. However, the court had applied the principle of ex post facto laws, and that is the cause arising of cause of action, thereby not giving Google the benefit of doubt in this case, also not having the very particular fact that probably they should have had a due diligence after they were informed to remove the particular information that has been considered as defamed. And also, there was a question that came out to be that when we talk about defamation, the person who has written, that person was dealt with ex parte. But how can that person be dealt ex parte and how Google could not have been a part of it? There's still lots of confusion behind it, right? And one of the biggest confusions why we have in our law is, number one, our IT law is taken as a buffer, and it is a buffer that works on almost all our transactions online. So if we have something like any misleading thing on IT or any misleading thing on internet, we put in our IT law. Or if it is something to do with our social media or internet media, we just put in our, you could say, just our old questions of just our data, or we just put in broadcasting laws, or we put in all such aspects only. That is what we particularly do in this particular case. But what we do not understand is that somehow our usual substantive laws have still not brought into change where the IT law could be accommodated, or IT law should be accommodated much in a behalf to fulfill the vacuum that have been created by already existing IPC laws. Let's just take example in this particular case while we were talking about defamation. Now, first of all, there is nothing called as cyber defamation. But let's just see what is happening practically in today's scenario. Every third day, there is a troll. Every third day, there is some meme that's coming up. There people are using such kind of awful language on internet that somehow it is nauseous. It is so disgusting that it can actually cause a lot of mental agony to people. This is that, but however, there is no control of any of this as far as our internet is concerned. The defense that we did have for the longest time was the defense under Section 66A of the Information Technology Act, which was repealed by the case of Shreya Singhal versus Union of India. Now, Section 66A of the IT Act holds a lot of importance, which says punishment for sending offensive messages through communication service, etc. Any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has menacing character, or any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will, persistently by making use of such computer resource or a communication device, or any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or recipient about the origin of such messages, shall be punishable with imprisonment for a term which may extend to 3 years and with fine. So let's go back to what happened when 66A was into picture. When 66A was under consideration, what used to happen was that oftentimes it was misused by the politics and the our legal authorities for the purpose of probably harassing or just arresting people they felt who were expressing their dissent over some of the uh, political maybe ideologies or political thoughts or some legal actions, anything. And that happened very well in the case of Shreya Singhal versus Union of India also. So this particular section was considered to be very grave and was considered to be very hard as far as its management and its implications and its application was concerned. So what started happening after a while is that people felt that this section is so monstrous in nature that it needs to be cut down. So although we cut down 66A, what we did not expect and what started happening was that the social media now started becoming a weapon. Now, after social media became a weapon, as that happened in this particular case also, that people started writing blogs, people have started using Facebook, people have started using any kind of technology that they can to so-called use their freedom of expression, but misuse it as their freedom of expression. I would actually use the word misuse the freedom of expression in order to bring in mental agony and discomfort over all the social media under the garb of dissemination of information. This is what is precisely happening at this point of time. So, after having a communication with a couple of lawyers who have been dealing with this idea of defamation happening online and what should be done as far as this regulation of intermediaries is concerned, so a lot of practicing lawyers, they had an idea that probably 66A, even though was repealed or something, it should be read down. There should be a provision which is less grave in nature instead of 66A, but it should be there to regulate the content on social media, because this is definitely getting a menace now. However, now comes our second criteria, and that was publishing. Something that we had a discussion in this particular case also, and that was the idea of publishing. Now we see that this case was put forth, and this case came in the year 2008. However, till now, you would see, as far as even the IPC cases are concerned, the books, the Bail Acts, they're just talking about publishing, right? Have they ever, in any place, have they mentioned exactly as to what all are they going to include in publishing? In latest precedents by the court, which are minded are not by the Supreme Court, a lot of high courts have made that observations. The WhatsApp chats, the Facebook communications have been taken as evidence, but they have nowhere been taken as something like an intermediary or responsibility. Now, the point here is, would WhatsApp be an intermediary? Would Facebook be an intermediary? Okay, for one instance, we can still accept WhatsApp to be an intermediary. But would Facebook to be an intermediary, but would the WhatsApp communication would also be a part of intermediary? Would the WhatsApp communication, especially when it is happening in a group, would that count as intermediary liability? WhatsApp communications personally, that is happening person to person, would that not come under the realm of data protection? If we allow and we are trying to regulate intermediaries the way the guidelines are given, would that not happen that somewhere we are trying to infringe upon the laws of data protection? Are we not trying to infringe the privacy of people somewhere? So, there are always a lot of conflicting ideas that are going along with. Coming back to the case when we were talking about publishing and defamation part. Now, in this case, till now, nobody has talked about 66A is not there. So now what we have right now with us is, at that time, I know 66A was there. We could have very well brought that. But anyways, this was not brought into question. Here they were discussing about just criminal defamation, 14 of 500, 499, 500 and issues of the IPC. Now let's go by what defamation is saying. It says that it is considered a defamation if you are trying to give certain kind of views that are offensive to the reputation and character of a person. Now, first imputation itself is defamation online. Are we trying to? There are a lot of places where the people are hashtagged. There are a lot of people where people are tagged. Sometimes the names are not given, but a common person can very well understand what is the implication of those kind of quotes or those kind of words that are used on media. But yet again, we have no cyber defamation mentioned anywhere. We have no defense of anything anywhere. So all we have to resort is to go to IPC. So now when we go to IPC, we have to first prove that there was publication. Now, when there was publication, then we have to go and prove it better again in the courts that because it was publication, it was disseminated to a lot of people. So now if we say that it was disseminated to a lot of people, a lot of times the observation by the courts and the level of awareness that our courts and our judiciary and our other legal fraternity has is that they will say, if you do not like it, don't watch it. So then ultimately the whole point is that the person is confused. The whole legal authority, legal paraphernalia is confused as to how they have to really bring in all these offenses. So the point here is, and my first observation is that somehow we have to fill in the vacuums. Instead of flying, going towards and saying that, oh my God, now we have information, we have artificial intelligence that is coming in. Let's get back to basics and let's just sort out our basics first. That are that self in so much of confusion and chaos because at some places there's overlapping of laws and some places there's no law itself. So then there is always a kind of confusion. Even the police do not know what they have to do. The problem is that even if people want to take an action, they do not know how to take an action. We have cyber cells, and cyber cells, most of the time what they say is that we had a very interesting talk with the person who was the IG of the cyber cell once. They had come in Chandigarh only and they were trying to tell us what is happening. He says, our success rate is not more than 2 to 3%. And then we were like, why should it be just 2 to 3%? Half the things happening on cyber cell. He says the problem is, how do we go convince somebody that there has been a cyber crime, first of all? Then when we do convince her that there is a kind of a cyber crime, the tracing of the crime and everything gets so delayed that probably by that time, the whole record is gone. The people are not understanding what is happening. There is some other issues, right? So somewhere there is a lacuna, somewhere there is a vacuum, somewhere there is a laxity in regulation that needs to be taken care of. And that is something that was highlighted in this particular case also. When we say that could Google be held responsible for the same, let's just go and see it from a completely objective mindset. First of all, number one, if we just take it in a very simple application, we can say, yes, the application of ex post facto laws can be there. And because the intermediary had no protection at that point of time, so Google was held liable. Okay, technical grounds are perfectly technical ones are fair. But how can you hold an intermediary responsible for the person who has published something? Now, for defamation, technically, if you go by what is IPC saying, that the person has to publish something somewhere against the person who feels the person is defamed. So where the person has published, how is that person supposed to be responsible unless you can actually prove the very fact that the person has connived to do it. Now, why would a thing like Google be interested in one remote industry in India to get a bet into doing something? They have absolutely zero interest in that. And that is exactly what happens in majority of times. If you're really wanting to regulate the, health, you hold the intermediaries liable, you have to hold them on a way where they are lacking in this self-regulations, where they are lacking in this self-censorships. Like we had the case of Cambridge Analytica. That was a very prominent phase where we can say the intermediary totally defaulted as far as the protections mechanisms that it should have held. It did not have it. Yes, hold the intermediaries responsible in situations like that. Then the data protection laws it did not take care of. When it was supposed to ensure that the privacy of the people are not privacy of people is ensured, and they did not do the same, hold them responsible for it. But then holding the intermediary responsible at that point of time, then probably all it did was exist. That's all. They were just existing. And because at that point of time, people could not have defamed somebody else in a letter or on a newspaper, they defamed on internet. That's all that happened. Right. So now holding the place that was used like this is somehow a very confusing thought process. Like somebody gave a very good example of it. They said that are you going to hold National Highway Authority of India responsible for accidents for accident if two cars collide? Can you hold National Authority of India liable for the same? They said that's the same thing as intermediaries. If there are two cars that are colliding, how would you hold the road responsible for it? Right. So that is the kind of thought process we have. But yes, if National Authority of India is supposed to manage the roads, it is supposed to ensure the fact that the roads are in good condition. The roads were made after proper assessment. The materials used to make the roads have not been bad. If there is some default on those respects, of course, the National Highway Authority can be held responsible, but not on aspects something like this, right? So this is what is the precise use or the thought of having our information technology or our having a brief idea about what intermediaries, their role, their evolving role has been discussed so far and so forth. Recently, about a day or two back, again, we had guidelines regulating the social media, where the government is giving guidelines as to how social media should be regulated. That has been put under OTT as to what the newspapers are supposed to say. Let me just give a brief outlook about the social media and their how social media is supposed to be regulated, right? Just let me just give me a second for this. Right. We were talking about social media and they be putting under OTT. Like I had described before, the government has given a certain guidelines for social media regulation by suggesting very well that they, especially even the news channels, if the print media, they all are supposed to be put under OTT now, that are put under broadcasting rules, they are going to be put under censorship, that have been exactly pre-existing in India as far as our normal television was concerned, that has now been going to be extended to all our internet TV also. Like very simply, I use the word internet TV. Our internet TV is simply to be understood as something that we have in form of Amazon, we have in form of Hotstar, we have in form of Netflix, we have Z5, we have plenty of our internet TVs now. So to regulate them, they have also been brought under the broadcasting and censorship rules, but how they're going to be applicable, we still have to wait and watch for the exact guidelines to come forth, right? So this is in brief as to what is pre-existing, what was pre-existing, how this case is going to impact us, and what is the discussion and where is the vacuum per se, right? So I would like to ask, is there, how should we go forward about it? Are there any questions or is there some part of discussion that we can have? Hema? Hello? Hello, am I audible?
Yes, ma'am, you're audible.
Right, right. So I was wondering that if you could have questions.
Ma'am, I'm checking the YouTube. I'm letting you know in the minute.
Okay, okay. So meanwhile, we could very well go by the very fact that if you people have any thoughts about this particular case, what are your opinions about this particular case when you went through this? What has been your analysis about this? Right. So, like we were discussing about the intermediaries and the missing of lines, and then we were discussing about how there is laxity in the application of laws. We have also been discussing about personality, how personally the police goes for it, and how judiciary very well understands it. The problem here, and one of the biggest issues here, is the lack of awareness in people. Also at the same time, there is also a very big problem about how the laws that are existing have to apply, and then of course there is a laxity in legislation itself, where the people are not understanding as to probably how the legislations have to be drafted to suit the needs of the people, right? uh, and in this particular case, we had three questions that have been discussed so far, and I could read about three of them. If you could just give me a second, where we were discussing these three questions. Just give me a second, please. Yes, the question here that, the first one that we have been discussing here was whether Google India was relevant intermediary, since the control over the group's feature was the Google in INC US corporation, which has not been implemented, but somehow it was. That was also used as one of the cases they were trying to, in one of the stages, that is in the pre cases in the High Court somewhere, they had implemented Google INC also. Now, the point here was that, yes, it was a relevant intermediary. We cannot deny the fact, because at that point of time, whether it is Google India or whether it is a subsidiary of a company, it is very well facilitating the share of information. Right. And then we were coming to the definition of safe harbor. We all have to see the very fact, like we have already discussed, what was going to happen, and what is the safe harbor idea about it. And that, I think, I have very well discussed, that safe harbor would be applicable only in case, most of the cases, only thing that the person or the intermediary that we are talking about has connivance. Like going back to the cases when cyber cafes were involved in majority of cyber crimes, what was happening was, in the cyber crimes, especially in relation to women, where there were issues of where we were issues about cyber connectivity, where there were issues of porn being shared, where there were issues of voyeurism, where there were issues of hacking. There, the cyber cafe owners a lot of times were responsible for the same. Why they were held responsible was that what they used to do, that just for the sake of money, and initially the very idea of having a cyber cafe was very easy. You get a few computers, you take a small room, make set up the whole system, have an internet connection, and there you could have a lot of people who used to go there, have communications hour-wise. They were also slowly, gradually becoming dens of majority of crimes. So that was the initial idea of actually regulating the cyber cafes. That is where the intermediary, and that is where the cyber cafe regulation first started coming into being. Slowly and gradually, like I had discussed earlier, in earlier part of my lecture, this cyber cafe got reduced and got into a format of having an internet on hand. It got into, we did not have to go to cyber cafe anymore. And with the COVID situation that we have had so far, I would say that the use of internet, the use of all those technologies has become something that is so easy. And for that matter, look at the kind of and how cheap it has become to use internet. We have work from home internet packages, we have work from home internet connections, where we have internet totally free, And just imagine at a place where it is unregulated and what is happening. Although some places also, if you go by the present intermediary guidelines, we have first mind out the rules. We are using the word guidelines. We are mentioning the word rules, but we are nowhere mentioning the word legislation. We are nowhere using the word act. We are nowhere using the word amendment. We are nowhere using the word that there is going to be certain kind of modification. Nothing. So how those rules and regulations and guidelines are going to be implemented, we all know the value, right? It is still something is in black and white, and there are certain amendments made in the already existing substantive systems. Nothing can very well change in the already existing scenario as far as the confusion and chaos, as far as the IT law and the already existing legal paraphernalia is concerned. In this case, we had issues with defamation. For me, I personally believe that there should be a special clause for cyber defamation itself. Cyber defamation for me is that kind of a defamation that is persistently going on more than the IPC defamation per se. Cyber defamation should have all the features of what goes on illegally, for that matter, legally, to control the menace of what goes on social media or what goes on in your WhatsApp communications. Of course, there should be a defamatory line that should be mentioned. But at the same time, I also urge for the fact that there should be a complete regard and respect of data protection rules, and there should also be a complete protection and regard to the privacy of a person, which is now recognized as a fundamental right. So somewhere we also have to give a due regard, but at the same time recognize the fact that how defamation is now becoming a cyber defamation, and the age-old law of existing in IPC would not suffice anymore for what is happening. Like for now, I think this lecture is live on YouTube. So there are people who are actually watching on YouTube. How many of them would not be writing, or maybe there are few people who are writing something on YouTube, some ulterior comment somewhere. Why do people really not understand the very fact that there is a difference in being or having freedom of speech and expression, and I would say the freedom where you are misusing that freedom of speech and expression? You're not supposed to do that. This media was meant for making something called as, in international terminology, we use the word as global common. Internet space, cyberspace is a global common. You cannot use this global common for your ulterior purpose. It will just redefine, it will misuse, it will completely destroy the already, so I would say the already existing, or what was the maximum purpose of having media, of having internet. It was not only defense, it was basically connection. It is helping people. A lot of times I would say people are helped because nothing else, at least during the time of COVID, people were able to see each other. People were FaceTiming, or they were just talking, or they were seeing each other, connecting their friends through internet. At least something of this was working. But if it is not going to be regulated anymore, and we are going to still struggle between what is an intermediary liability, how the intermediary liability should be mentioned, how the defamation online should be handled, what is going to entail defamation online, if we all are going to just keep focusing on issues something like this, then I just fail to understand probably our very purpose of having an internet so free and so accessible to people is going to fail. So that is, I would say, the need of the hour. That is to focus on the very fact that when we are using something like, I generally quote Spider-Man. I would say he's one of my favorites here. With great power comes great responsibility. So just like Spider-Man says, with the great power of internet also comes the responsibility of regulating it, managing it, and using it in the right way. So with this, I would like to conclude my talk here. Yeah. So can we directly have questions, please?
Yes, ma'am. We have a couple of questions for you.
Yeah, sure,
First
please.
question is, will the government make a move to invade our privacy, ma'am?
It is possible. It is very much possible because of the very fact that the kind of guidelines that we had, especially when we talk about regulation of media, like there is a fear that they may be snooping. You understand the meaning of snooping is that sometimes what happens is when intermediary is going to be asked to regulate it this way, there is a possibility, there is a probability, possibility. I'm not saying, because till the time We do not know how it is actually implemented. We cannot comment how things would be, right? So what we can just anticipate is that if the intermediaries are asked to regulate the content, probably they would be going to a level of filtration or action into going into details on our own IDs or something. So snooping can very well happen. This has been alleged by a lot of experts. They are saying that there is a possibility and a probability of snooping.
Ma'am, a couple of days back, the OTT rules and regulations were released by the government. So how far it is effective, ma'am?
We have to actually see, let those rules come first. We have to first see how those rules, again, that's what I'm saying. This all is so nascent. We actually have to see how they're implemented. Let them be implemented, then we can actually comment how they have been effectuated, right? Then again, I'm saying the words that we're using here are guidelines and rules. Nowhere we're using the word legislation. Nowhere we're using the word act. Nowhere we are saying that this kind of an act has come to regulate social media. Nowhere. So when there are guidelines and rules, how would they be affected? Where are they going to be used? How much of awareness? Which authorities are going to get a power? That is a question we will see only when they're implemented and brought into action.
Ma'am, but how can we cope up with such type of fraudulent cases in online mode, ma'am?
It is very difficult. I'm telling you personally, because all this COVID time, I have been closely working with I had a couple of incidences with the cyber cell and the judiciary themselves. So then I can very well talk about this. It is actually getting very difficult. At that point of time, during the COVID time, all this time period, the cyber cell was saying that probably the number of cases that they have received so far had increased over time as much they had never received till 2020. It was getting very difficult to manage because see, everything is happening online, right? So, and imagine the population that we have, and so much of it is online, inclusive of even the kids are online. So how much of interaction and how much of mismanagement and management will happen, right? So we do have laws that talk about the fraudulent use. We talk about that the frauds, the cheatings and all that, how they can be done. But still, despite the very fact, there have been cases where people have had frauds with their bank accounts. The money was stolen. The cyber cells have written it. The police, they try their very best to act. Like if you give them a complaint within a matter of say, because of the high number of complaints, in a matter of 2 months, probably they process the complaint and then they try and bring an action to it as fast as they can. But then you see by that time the loss has already happened, right? So somehow we do not have mechanism there. Even technology is also lacking, that somewhere we do not have a mechanism to stop it, right? Even though we are having everything fintech, we do not have a mechanism to stop it. Even if you have online transactions, we do not have a time to stop it. I always, tell my students, I said, as much you exist on Instagram and Facebook, be very sure of it. The day you make yourself a digital identity, you say your privacy goodbye. The more you're found on all social media links, you have Instagram, Facebook, name anything that you have, your privacy has gone. You exist. Your digital footprints are not going anywhere. They're going to be stored in the cloud. They can be retrieved. Not a very hard thing. Your privacy, you could just forget it after that while. That is what is a sense of how they can be used.
Ma'am, one of our attendees, Rishabh, is thanking you for all the information and the session which you have taken. And his question is, do we expect a data privacy legislation or provision to come in force?
Yes, definitely. That much is definitely in line. After Puttaswamy judgment, we did have a mention about data protection laws. So I think probably in next coming time, in a matter of a year or so, we should definitely have a data protection rule coming up. Data protection law will definitely be there on the lines, like if you would like to refer to, we would definitely be and mostly following the pattern of EU in this, that is GDPR guidelines, right? Mostly we will go by those that pattern, and that is how we will define what our laws are and how we should be going by the data protection part. So that is what it is going to be.
Our next question is, ma'am, what sort of regulation would be appropriate, like self-regulation or institutional regulation?
I would say let's have, I would say a mix of both. Somehow a mix of both. Why I say this is, you see, institute like this, or for every organization, whether it is Amazon, whether it is Netflix, they have their country specific centers. And now, going by the very fact, China and India are big markets, right? So when you have excess of big markets like this, then at that time you should ensure a bit of self-regulation by yourself also, because you're catering to a huge market one side. You have a huge consumer base. But at the same time, we also need legislations to suit the national needs. And mind the word, I'm using the word national needs. Please, that is what I would want to emphasize on, right? That is it. It should be a mix of both.
With this, we come to an end of the very informative and interactive session. Not taking more of your time, ma'am. We are really thankful to you for your enlightening us on this recent case and making us understand its intricacies. The concept of intermediaries, their role, functions has been so easily explained by you that it has been a wonderful experience learning it. I, Hima Mudin, would like to thank WCSF team for putting up such an effective and informative webinar. Last but not the least, I would like to thank ma'am and each and every attendee for being such a wonderful and patient audience. Thank you so much, ma'am.
Thank you
Feedback?
so. Sorry.
Yes, ma'am.
Continue.
I just wanted to inform the attendees that the feedback form will be shared in the comment box. All the attendees are requested to fill the form to receive their certificates. Looking forward to your participation in future events. Yes, ma'am, you can please.
Yeah, I would say it was indeed a delight to be part of this talk. It actually, I would say it was so nice. I could share my thoughts, and the audience has been wonderful. The questions were also very good. So thank you for such a wonderful interactive session. And I look forward to such sessions, more such sessions. Thank you so much. Thank you, all of you. I would like to thank the team that organized, that's a World Cybersecurity team, to organize this kind of webinar. I congratulate them, and I hope and pray that they organize many sessions ahead, and all the best to the team and everybody involved. Thank you so much.
Thank you so much, ma'am.
Thank you.